Names of 11 clergy shielded from grand jury report on sex abuse in Catholic Church. The priests went to court to challenge being named in the document before it was made public in August. They argued they had not been provided an adequate opportunity to respond to the allegations against them to the grand jury, describing the report in a court brief as containing false, misleading, incorrect and unsupported assertions. "We're just gratified that the court undertook a substantial effort to vindicate a core Pennsylvania constitutional right, and procedural safeguards to ensure that that right is honored in the future," Attorney Chris Hall, who represents some of the petitioners, said Monday. Ephraim Grail, another lawyer with clients who challenged disclosure, said he was gratified by the ruling. "Its opinion clearly demonstrates the constitutional inadequacy of the Commonwealth's Investigating Grand Jury Act for the injustice of its procedures," Grail said. The grand jury found hundreds of priests had abused children over the prior 70 years, describing abuse that included violent sexual attacks. The report, which was issued with extensive redactions while the priest's legal challenge was pending, also said church officials covered up the abuse. The grand jury focused on 301 clergy, and more than 270 names were made public in August. It was not immediately clear what will happen regarding clergy whose names have not been disclosed but are also not among the 11 in the Supreme Court decision. As a general matter, lawyers for the priests wrote in a September 4 brief, "A private citizen singled out for targeted condemnation in a grand jury report must have what other jurisdictions provide, an opportunity to present exculpatory evidence to the grand jury, and a hearing before a neutral supervising judge. They have said essential witnesses are no longer available. The report has created a lifetime stigma of sex offender status without criminal convictions, and the Attorney General's office had engaged in an incessant media campaign." The Attorney General's office had argued the Supreme Court could have brought the now dismissed grand jury back to hear testimony and examine additional evidence. The state prosecutor's office has said the court could change the grand jury process through its rule-making power, bypassing the legislature. The Attorney General's office said permitting the names to remain redacted could set a precedent that would impede future efforts to expose institutional abuse or corruption. Todd wrote that altering the grand jury's procedures is a task committed to the sound discretion of the legislature. In a lone concurrence, Justice Kevin Doherty suggested giving those named in grand jury reports the right to testify and other changes designed to protect their constitutional rights. The dissent, by Chief Justice Thomas Saylor, endorsed granting the petitioners a limited hearing before the judge who supervised the grand jury, and letting that judge make reasonable judgments concerning whether, and to what extent, the petitioners would be permitted to review and test the evidence upon which the grand jurors relied.